Well, welcome everyone to tonight's class. We are now week 7 here. Tonight we'll be covering Chapter 8, which is on the contractual risk transfer. This is probably one of the, at least for risk managers, in my view, underappreciated form of risk management. It's probably the most utilized, and most people don't even realize that they're entering into contracts basically on a daily basis, whether they're, especially now on the web and those type of things. And while lawyers or the attorneys in a firm may be handling the contracts, from a risk management perspective, I mean, the contracts are probably more essential to the, what a risk manager does, and it can be the most effective and most inexpensive means to actually transfer risk. To me, this is probably one of the most important chapters that's actually in the book as we discuss it. And I think you'll see how that kind of relates. So one of the things I added in here that I'll show, this is actually the parking stub from when I parked this morning at the City of Sacramento Public Parking. One of the things you'll notice on this says at the very beginning that this is a contract. This limits our liability. Read it. And basically goes through a couple things as it talks about on there. And one of the things it talks about, this is a license to park a single vehicle in designated area at your sole risk. No bailment is created. Now, we talked about bailment, I think in previous in 55 was when we talked a little bit about bailment. For those that haven't taken that, basically bailment, the idea behind that is a bailment condition is created from an insurance standpoint if you take your car into a service station or garage and they keep it overnight. Under bailment, they're taking the care of the car, which means that anything happens to it while it's in their care, they're responsible. Their garage liability coverage will essentially cover any damage. What this contract is stating, by me pulling the ticket out and deciding to stay and park my car, that I've agreed to the terms and conditions that I am not going to sue if anything happens to my car while it's there, because it's basically said, again, no bailments created. There'll be other signs and notices typically throughout the parking garage on that as well. I'm also going to just show you a couple other contracts and terms and conditions that are fairly common. So some people use Survey Gizmo, Survey Monkey, other types of things. So I pulled this off of Survey Monkey. And this, again, from a contractual standpoint, talks about the warranty disclaimer. And then also you see limitation liability as part of 14. And what it's basically from their liability, what they're saying in this, on the first one under 14.1, for any breach or default by widgets, kind of goes through the official language. The amount that they're liable for, I'll go right here, shall be no event ever exceed any of the following: a fees paid to widgets by the customer pursuant to this agreement in the prior 3 months. Make sure that, okay, just want to make sure I got a question there. Prior to the agreement for the prior 3 months, so that's the amount of money in that case. Or in the aggregate with respect to all claims made under or related to this agreement, the amount paid by the customer under this agreement in the preceding 12-month period. So essentially what this contract is saying is that for whatever reason I use their software and I use it for a big project that's a $10,000 project, and something happened, they lost my data. The limit of their liability under this contract is basically what I paid for it. So if you do the free service, in which you didn't pay anything, there is no liability. If you paid $100 for over the last 12 months, that's the limit of their liability. You'll find this pretty much on almost any web-based software, Quicken, other types of things. It'll be different for different types of software, but for the most part, almost all software will have a limit of liability of what you paid for the software. They can't say that they have no liability, because the courts would say, well, that's not proper, that there has to be some liability if there's a failure on the part of the software. But they can't anticipate how people are going to use it or what the costs are. Another one I'm going to go ahead and show on here is this is actually, where did I get this one? QuickBooks. So this is another one. It talks about on the site terms, termination, indemnification. They'll have these things. And almost any time you go on a website, or if you go into a hotel, you have a little button that says terms and conditions. These are things that almost no one ever reads. But what you're agreeing to in most cases is that either you're not going to sue, or that limits the liability of how you can handle those type of claims. So that's why this is so important, is that every day we're entering into contracts, and no one really takes the time to really read them. We take the time to maybe read that from when we're buying a house, and we'll actually read through all that fine print of all that paperwork. But some of these most basic things, we're pretty much giving our rights away in most of these cases. And even in this case on indemnification, by using QuickBooks, you still agree to indemnify, defend, and hold harmless QuickBooks, its directors, and so on, attorneys, if you use this negligently or for wrongful conduct. So even in this case, you're indemnifying the organization which you're buying the software from. So again, contracts mean things, and I think it's important for people to basically be able to recognize that aspect of it. So we'll go back to the slides here. So one of the questions was asked here. It says, always wondered why some parts are always in all caps. Why? Well, part of that, so that's actually a good question, is that it has to be obvious that it's important. And so if it was all kind of kept in small little language, you wouldn't find it that has importance. So if this was to go to court where someone challenged this and said, well, I didn't know, the fact that it's in all caps, it had different fonts, different colors, all those type of things can basically be arguments that they provided notice. Basically what this contract, what they're intending to do, and we talked about this in 55 as well, you have to provide notice, a proper notice to those that are entering into a contract. They have to be informed. And by taking the ticket, and they have the signs up that's essentially how they're making sure that you're providing notice. So that's why you'll see things in all caps quite often.
It's ironic that putting things in all caps actually makes them harder to read.
And as Emily said, it also makes it harder to read sometimes when things are all in caps. But yeah, that's actually one of the things that they do look at to make it look different. And then also you look, keep ticket with you, must have it. Those are things they're trying to make sure that you as a customer are fully aware of what those provisions are. So based upon that, so what are we going to talk about tonight? When we talk about risk, contractual risk transfer, we need to be able to, from this chapter, describe the types of contractual risk transfer for hazard risk, which we'll be more specific on that. Describe contractual risk transfer by type of transaction. Explain how contractual risk transfer for hazard risk can alter common law liabilities. Describe the types of statutory limitations on hold harmless agreements. And then finally, explain how to manage contractual risk transfer for hazard risk. And a large part of the last part is, it's monitoring insurance agreements. It's, making sure that someone does read contracts, things like that. But so these are really the 5 objectives that we have for this. And hopefully, as we go through this, this will probably make it's kind of like, okay, now you understand why people do these things. Why do I have to sign this contract? Why do I go to a bounce house? They have to sign a waiver for my kids to jump and all that type of thing. And it's largely because it's indemnification and waiver of liability that we're trying to do. So when we talk about types of contractual risk transfer, we're really talking about, in this context, there's 2 types. There's non-insurance risk control transfer and non-insurance risk financing transfer. And it's really the difference between the two. I highlight in this case on the bottom one, but transferring not under risk control transfer. You're transferring the risk itself is a risk control technique because it rids the transfer of some or all of the loss exposure. Okay. So risk control is more the activity, whereas when we talk about risk finance, when we transfer changes neither the frequency nor the severity of potential losses, but only who pays for the losses when they occur. So then that point it involves the risk financing. So when you think about a risk financing, that by signing a contract, by me entering that garage, that I parked my car, it doesn't negate the possibility of someone vandalizing or damaging or something happening in my car. The only issue, what they've transferred in this case, is that they pretty much say, we're not responsible and our insurance company is not going to pay for any claims. So they basically transferred who pays. When we talk about risk control, non-risk control transfer, it's the techniques. We might be contracting out services that we're not going to do window washing. In that case, we've reduced through a contract by someone performing that service rather than us. We've contracted essentially the risk of that activity to someone else, to where we don't have, if we don't do it, we don't have any frequency concerns in that regard. And hopefully then also they'll have insurance agreements that will be part of that as well. So usually even in professional service agreements, it's really going to be both things that you're going to be looking at. The types of non-insurance risk transfer, some of the considerations that you need to have. That it's important, and this is key, that a contract is formed before any loss occurs. So the idea that I entered the parking garage, I get noticed by the signs out there, and I pull the ticket, and I pretty much have been given notice. There's a contract that's formed before I enter. One of the things that happens, that the concern is that once you enter and then, before you leave it, if you get a contract after the fact, you might say, well, I would have never agreed to these things. I would have parked in a different parking garage. Well, that's why these things occur in the very beginning. It's at what point the contract is formed. The other consideration is risk financing transfer only provides protection only after funds to restore loss are paid. So the idea when you do risk transfer is that you're still going to suffer a loss, most likely, when we're talking about the financing aspect. You're going to suffer a loss, and then you're looking for recouping of those dollars, so that way you'll be made whole again. So just like when we talk about risk control of preventing the loss, under risk financing, it's really indemnification. We're waiting for that money to come back to us to help restore and make us whole. The other concern is issue of bankruptcy and insured endorsements. So if you enter into a contract and based upon maybe the contract is for someone to provide services to do certain things, or I'm trying to think of a good example here, but one of the concerns that organizations have is if a company goes out of business, well, who pays the claim? If there's no insurance that's part of that. And the other aspect of it is that if the company doesn't maintain its insurance, so if I contract with a professional service, party, they injure an employee while they're here, they do something that injures our employee, we basically subrogate against the claim, and then we find out that they have no insurance, that the insurance coverage they have is lapsed, and that the company that we're doing business with doesn't have the means to pay us. So just as much as having a contractual insurance agreement is important, you got to also make sure that the people you're contracting with have the means to pay, or that they have the insurance as part of that. So we'll talk about insured endorsements after that a little bit. So the question is, are you saying risk financing transfer is a reimbursement? In other words, I pay and then you has indemnified or reimbursement? Yeah, basically, yeah. I mean, well, it depends on the contract. For the most part, once a loss occurs, it depends on if there's an indemnification or if it's just that they're going to make us whole again. What we'll talk about as we go through this is that in some cases that if someone sues us, if there's an indemnification clause, that they will basically pay for the attorney's fees up front in some cases. They'll pay for those things to defend us in the event that there's a lawsuit. But if we have a loss on our property, most of the time what happens is we will handle the claim internally, and then we're going to subrogate or we're trying to get recovery for those dollars. So it really depends on the situation. But in most cases, if we have a loss, we're going to pay it first. We want to make sure our people are taken care of, and then we're going to go after, because we don't want them to wait 6 months as we're trying to fight the battle if they have an injury. And also under workers' comp, for example, we would have to pay that under the law first and then subrogate afterwards. So some of the types of non-insurance risk control transfers. As it mentions, most of these times, in most cases, this is going to be dealt by your attorneys, Office of General Counsel. They're going to be the ones really focusing on these issues. But some of the most common, incorporation. And so why is incorporation in the book talks about segregation as being a form of that. The idea that as a company, you may have different operations. I'll give an example where this comes into play. Raley's Supermarkets, who I once worked for. Raley's as a corporation, it's family owned, and they have the stores. They also own the trucking company that delivers the products. They also own a warehouse facility that basically houses all the products. Each one of those is a separate corporation. The idea being, if there's a major accident involving, let's say, the trucking, where something happens on the roadways, where a pileup or something, it won't affect the operations of the grocery chain because it's a separate corporation, has separate insurance agreements, so they can't go after the different. It's a completely different entity, and so by incorporating and basically segregating out your different operations, that is a mean of risk, really of risk control, non-insurance risk control, because each one is really a standalone in that regard. Leasing, we'll talk more about a sale and leaseback arrangement here, but leasing, almost in every lease agreement, there's provisions in there of who's responsible. And in most cases, when we talk about contracts, it has language of minimum insurance requirements. So we have language with all of our standard contracts. Anyone doing work with us has to maintain a minimum amount of insurance based on the type of work that they're performing. When we contract for services, professional service agreements, that's a form of non-insurance risk control transfer. We'll talk more about surety shipping guarantee agreements. Typically, when we talk about those, that's construction or performance contracts. We talk about guarantee that the work is actually going to be performed. Waivers, facility use agreements or activity use, such as bounce houses or community service districts. They'll have some type of indemnification and waiver. Limitations of liability is another form of contract, which is where I give examples of computer software. And disclaimer of warranties, used cars. Basically, you're buying it as is. That's really what a disclaimer of warranties is. And you even saw that language on some of the websites that I just showed. There's a disclaimer or warranties, what's covered, things like that are part of that. So to go a little specific on some of the things that we'll talk about. So one is on leasing. And what I'm going to try to do is hopefully provide you context of why you would do some of these things. And it talks a little bit about the book. But so under a lease arrangement, it's pretty common for a developer, or let's say a grocery chain. They will build a shopping center. And after it's built, they'll sell it, and they'll have a leaseback arrangement. So, well, why would they want to do that? Well, part of it from a risk control standpoint is they free up capital. They invested all this money. Now they sell it. They get this money back. And now they are just a tenant, and they don't have to worry about all the other issues. Because if you think about it, a grocery store, they're in the business to sell groceries. But if they have other tenants, that means now they have to have someone that manages all the other properties, make sure there's insurance, does inspections, make sure the parking lot's striped, all those other types of things, which is not typically part of their core business. And so they'll sell to a management firm to basically do that. Now, I put in there common area management. Within that type of realm, using a grocery store as an example, but there's typically what they call a CAM agreement, and so that's common area management. And under a CAM agreement, each of the tenants has certain responsibilities, and it also dictates what part of the parking lot's theirs, what do they have to maintain, the sidewalk. So it also stipulates if a slip and fall occurs at this part of the property, who's going to pay for that claim? Is it the common area management company, or is it the tenant? ADA, and so the big issues typically on common area management is ADA, American with Disabilities Act requirements, because most, unfortunately, that becomes still an issue of ADA, meeting ADA requirements. And so when a organization is put on notice, if the parking lot is the wrong slope, is that the fault of Target or some other company? Or is the common area management. So that's really the reason why you see from a leasing, the risk control transfer is a portion of that. And then sidewalk maintenance. Typically you see lots of trip and falls because of lifting sidewalks. And so that becomes their responsibility as well. I'll give an example also from a leasing arrangement that for Office of the President here in our office, we actually have we have a 12-story building. We have parking garage. On the bottom floor, we actually have a cafe. Well, a fire started in the cafe. It was put out, but part of the issue is since we're self-insured, what insurance requirements did they have, those type of things. So that becomes part of this whole agreement of what was in the lease. So when people go, well, how quickly can they get up and running? Is this covered? It all goes back to the contract, what's in the lease contract, and what's our obligations to make them whole. And also goes to whose responsibility was it? Was the fire caused because of what they were doing, or was the fire caused on our end? So all that goes right back into what is the language that's in the lease agreement. Contracting for services. This is probably the most common, that all organizations contract for services to some extent, whether it even be janitorial services, window washing, anyone that does any type of service for another organization, they're contracting for services. So in this case, generally any property, net income, or personal loss exposure can be transferred fairly easy. The challenge is liability loss exposures causing harm to third parties are more difficult to transfer. So what that means is that if we have people, it's one thing if they cause, if we have people, let's say janitorial crew comes in and they do something, that they spray something that causes, respiratory conditions where people hear, that's easy to take care of. But if they do something to where it's a third party, meaning that it's a visitor coming to our building and something happens, that's more of a challenge to try to to transfer that type of liability from a responsibility, because the person can, who's the person going to sue? How do we make that person whole? And then also the issue is that many times when you think of contracting for services, even like building, you might have a general contractor, and then that general contractor is hiring other people as subcontractors. So while your general contractor may have the proper insurance, the subcontractors may not. And this has happened where I'll give, Walmart as an example. They hired a firm that would do cleanup at night, so they would clean the floors. Well, the subcontracting firm they hired basically was hiring illegal immigrants, and they didn't have insurance. They weren't paying workers' comp, and so then you run into an issue of, okay, well, Walmart looks bad because of how this looks, and basically everyone, and so the liability would then fall back essentially on Walmart, essentially to make them whole if the general contractor can't do that. So what's in the contract is really important, and usually contracts will now say, as lessons learned through this, is it says the general contractor has to maintain certain insurance, and that they also have to ensure that in the event a subcontractor doesn't have it, that they will cover for subcontractors in the event that they don't have the proper insurance. So again, we're trying to transfer that liability to the subcontractor essentially onto the general contractor in doing that. So I think as we go through tonight, you're kind of seeing, from an example standpoint, you can probably think of a lot of things that you've probably seen at your own organizations now, and you kind of go, okay, this is what could happen, what could go wrong. Is there a contract in place? And that's really the kind of the what-if questions that risk managers need to ask. And you kind of go, wow, there's contracts for everything. How do you manage all that? And that really becomes the big piece of the puzzle is how, do you think bring things in-house? Do you have to hire someone that's just a contract manager to maintain all these type of agreements to manage that? So this one another one is on surety agreements, and we'll talk about guarantee agreements in a moment. But the idea of the surety agreement, and hopefully, and someone asked earlier about, in the text it talks about transferor and transferee and leaseor and leasee, and if there's any kind of mnemonic way to do that. The only thing I can come up with is if you kind of think transferor, it's for someone. That means we're going to transfer to another person, whereas transferee is like me, I'm the one that's going to accept it. Whether that helps or not, so leasee would be, that's, I'm the person that's going to take it on as me, whereas transferor, I'm giving it to someone, it's for someone else. So whether that helps or not, that was the best I could come up with, some of the mnemonics here. So on a security agreement, you kind of look at it, how does this work when it talks about obligee, principal, and the surety, who's doing what? So the obligee in this case is if, if I'm the one that's doing work, or I hire someone to basically take out, let's use building. That a building was supposed to be built under a certain time frame, or to certain specifications. And if the contractor doesn't perform for whatever reason, there's usually some type of surety agreement that will cover me in the event that this happens. And part of that surety agreement is also to ensure that if this person doesn't perform, I can use that money to hire someone else to either complete the project. So it's somewhat of a guarantee. The money's not actually transferred until the actual loss occurs, so it's kind of almost like a credit to a certain extent. And a lot of times on surety bonds, we might be talking about like $10,000. For large projects, it'll be much higher than that. It depends on the type, what goes on here. So, so in this case, the principal obligor is that the money paid to principal obligor if promise to perform is not kept. So this person, I'm the homeowner, let's just say. So in this case, if we look at it, money paid to principal obligor if promise to perform is not kept, so the money would go here. The obligee, this is the person that's required to perform the work, that they're going to be doing the work, and then we also have the surety that basically goes here. The bond paid to the surety is part of this. Now, this probably the graphic's not probably the best, but the idea behind this, and this is probably the most the key point behind this, is that the way a surety bond or surety agreement works, it's really a contract to ensure performance. It's a performance contract. And it's to basically ensure the proper performance, and then guarantee. There's a couple things in here that that it talks about. A surety has several rights that protect it against loss from the principal's misconduct or from collusion between the principal and the obligee in this case. So the first one's exoneration. For example, assume a principal has fallen behind his project schedule and the obligee has failed to preserve its rights against the principal. In such case, the surety is released from the liability. To that extent, it can show that the obligee's inaction increased the loss. So, again, the idea, so the principal has fallen behind its project schedule. Okay, so that is the, actually, in this case, I'm sorry, I messed up on what I described earlier. The principal would be the builder in this case. And the obligee has failed to preserve its rights against the principal, meaning that I didn't give, I kept on saying, oh, it's okay, those type of things, and that would be the case. What they're worried about in this is that there's any type of collusion that basically would warrant that the payment would be made because, quid pro quo, those type of things. And so in certain conditions, this would be the case in which, it could be the surety would not have to pay. And it talks about subrogation clause, which entitles the surety to the same payment the principal would have received. For example, the surety completes the construction of a building after the default of the building, the contractor principal, in this case, the building owner, the obligee must pay the surety for the portion of the work completed on the same basis on which it would have been paid to the contractor. So this is the case in which that because the work was performed by someone else, that's the subrogation aspect, essentially, is what they're talking about. The default of the building contractor, they're going to pay that surety to the work completed to another contractor that would have been paid, essentially. And the indemnity portion, the surety can proceed directly against the principal to recover the fair value of its effort, and any funds it has paid to obligee as compensation for the principal's inaction. And the principal must indemnify the surety for the loss. Now, as far as questions on this, people kind of, I know there's not going to, if there is, there's only going to be one question on this area. This part can be confusing because it's trying to figure out who's the principal, where does the money flow, and so the main concept that, if anything, they're going to look at is what purpose would you use a surety contract is typically the type of question you're going to get. Again, a 50,000-foot level is what they're going to be looking at on this type of question. When we talk about waivers, so as a waiver, just as it sounds, it's a voluntary relinquishment of a known right. So if we waive, we can waive our right to sue, we can waive our right to subrogation, and that's also done through some type of contract. So then there can be, typically within there'll be what's called an exculpatory clause or agreement. It's a contractual provision purporting to excuse a party from liability resulting from negligence or an otherwise wrongful act. So when it says a provision purporting to excuse a party from liability, there used to be, there's case law now, there used to be a lot of these contracts would say it would waive even gross negligence on the part of a owner or other type of thing. And what's basically the courts have thrown that out, that you can't waive gross negligence. You can waive negligence, but not gross negligence. And so there'll usually be a provision in there saying resulting from the negligence. So the idea, why would you waive, how can you waive negligence? If you have employees, could they be negligent that they forgot to do something that day? They forgot to, check, I'm trying to think, a piece of equipment. Now, in some cases, a piece of equipment, if it's the most important piece and they didn't use their checklist, that could be an issue. And then I'll answer it. So Hans, on the question on the Surety graphic, going back to that, it says, is that a typo, money paid to principal contractor if promises to perform not kept? Doesn't the contractor pay the owner, principal pay obligee? What I'll do is I'll go back on this one, and we'll address this at the end. So we can move on, but that's I can see where the confusion is there. So the other piece on this is waiver of subrogation. So and another person sent in a question regarding this, because when we talk about it, it's a pre-loss voluntary relinquishment by an insurer of its right to seek reimbursement for payment for damages that were caused by a party other than the insured. Okay, so there's a different type. There's kind of a general waiver which says I'm not going to sue you. Okay, that it's when we talk about waivers, we're talking usually hold harmless agreements. There's language in there. A waiver of subrogation is a little bit different, because what it's saying is, in this case, it's a relinquishment by an insurer of its right to seek reimbursement for payment for damages that were caused by a party other than the insured. So if someone gets in a car accident, what typically happens is if there's multiple parties involved, at some point there'll be a request, a waiver of subrogation, and a lot of times it talks about pre-loss. There might be an agreement beforehand, but there might be, as part of a settlement, a waiver of subrogation saying, look, if you agree to this, you also have to waive your rights to subrogate the claim to basically go after anyone else. So, subrogation, I guess probably define it, is any time, it's basically after a claim is made and you paid out, subrogating is going after the party which then caused the damage to try to recover those funds. So when we waive our subrogation rights, we can, as you see, we can waive our subrogation rights and say that we're not going to seek a reimbursement for payment by the other party because the payment was maybe made directly to the employee, or the waiver of subrogation might go directly to the employee saying, look, they're not going to sue the other parties, or if they do, any monies recovered as part of that will go back to the university to help pay for the claim. It's the whole idea behind the waivers is that it's kind of like double jeopardy in some cases of how far you're going to try to get that subrogation. So that's where the waiver of subrogation comes in. And I thought I printed off. I didn't bring the specific question, but on that one. So one of the things also, just keep in mind, because with the Institute's books, for those that read, they do make typos, actually more than you might think, and in some cases things are not necessarily the best worded, and they actually have a correction. At some point they'll issue like a correction kind of sheet based upon the pages, probably later on as people bring these issues up. So if you do find those things, certainly email me, and I'll email those to the institutes, and we'll have them look into those. The last part of this is, to be effective, a waiver should comply with the following criteria. The waiving party must not have been forced to sign it by even bargaining power. The idea that they're put in forced in a position to sign the waiver. And when we talk about uneven bargaining power, you can say, well, I parked in the garage. I kind of, was there a waiver on that? Well, typically, a waiver does require a signature on that part. It must be obtained honestly and not by deceit or concealment. In other words, it needs to be plain language. It needs to be not in smaller fonts, hidden, that people have a fair, when they look at it, they'll understand it. It must state the specific right that is being waived in a clear and unambiguous manner. So the idea that you're not going to be able to sue. You're indemnifying both, but you're waiving your right to sue for these reasons. And a whole fee supported by legal consideration paid to the party waiving the right, meaning that because of the activity that they're performing, they paid to perform that activity. You also acknowledge, and part of this waiver must acknowledge that this activity is dangerous. It could result in death, disfigurement, things like that. You'll typically see that in a waiver. What's happened with case law, and this is kind of not necessarily on the test, but I think gives some good foundation, is that what you're finding if you go to a community service district, at least in California, they will have a specific waiver for each type of activity. And the reason why they did that is what they found is they used to have a general waiver saying in performing any of these activities that you waive your rights. The problem is in a community service district, you have yoga, you have flag football, you've got martial arts, you have all these different types of activities that have varying degrees of potential injury. And so with the waiver requirements, what was happening is the courts were throwing out these general waivers because they basically said you did not inform the person as they're signing of what the potential injury was. And so now you'll see a specific waiver for football. You'll see a specific waiver for those things saying you could have these type of injuries as a result of playing flag football. So, more paperwork for everyone to sign, but that's why you see that. And you also see that in bounce houses as well, why they have specific language there. So we're now moving on to risk control transfer. As we kind of look at that issue. So limitations of liability. And what is that? So when we talk about that, it basically, in this case, software language limiting liability to purchase price of software. So here's an example of language that you can find on something like that. But under limitations of liability, depending on the type of contract, it might be if it's a building, it's the cost of construction. It depends. But basically, limitation of liability, it's a specific language that will be in a contract that says what the limitations are. I mean, it is what it is. Disclaimer of warranties. In this case, may deny any express warranties made in conjunction with the property sale. So in this case, most car dealers, when you buy a used car, you're buying it as is. Any warranties, made verbally, basically saying anything that I said verbally, I can't guarantee it because this is what the contract you're signing saying as is. So it talks about disclaims all warranties of any kind, either express or implied, including without limitation, implied warranties of fitness for a particular purpose and merchantability. So it's buyer beware in this case. I mean, that's part of, now, you'll also find, of course, there'll be warranties to say we warrant this for up to a year, we warrant these type of things for up to a certain time period. But then you also did say disclaimer. It just depends on what the contract language is, and that's why it's so important, again, to read contracts as you do so. So you can't, even if you sell your own car and you do a private sale, strongly encourage you have a bill of sale which has a warranty which says you're selling it as is, because you may say this car ran great, no problems, that type of thing. Could someone go back with, on that? It's potentially, and that's why it's important that if anything, it just says you sold this as is. Finally, hold harmless agreements. So hold harmless is a contract under which one party agrees to assume the liability of a second party on those specific activities outlined in the contract. Indemnity clause provides transfer with funds for restoring accidental losses to property, net income, and liability claims. So this kind of goes back to the transferee shall hold harmless. So the transfer means me in this case. Shall hold harmless and indemnify the transferor, the company, the person that's transferring, indemnifying, for any losses, claims, damages, awards, penalties, or injuries incurred by any third party, including reasonable attorney fees. So it's very specific. It spells out what those things are. And also the indemnifying party shall have the sole right to defend such claims at its own expense, and the other party shall provide at the indemnifying party's expense such assistance in investigating and defending such claims as it may request. And this indemnity shall survive the termination of this agreement. So basically means if at a later point you're no longer using the services, that essentially the indemnity for the life basically survives. They can go back and say, if something happens, they can still say you've indemnified us for those activities. This is probably the most important language you'll see in any contract is hold harmless language, because basically what this is saying that if anything happens, if I have any losses, I'm going to recover those dollars. It's going to the indemnity clause in this case provide transfer with funds for restoring accidental losses to property from these claims. And essentially, in a lot of times we'll see this one says only hold harmless, indemnify. Some will say defend as well, which means that they'll also pay for the defense and will act on that behalf. Again, depends on what the contract states. The transfer of risk to transferees insurer. So this is what's called typically, you see, additional insured endorsement. There's a couple ways you can do this. So a lot of times what happens is someone will say, add me to your insurance or whatever. And so what they're basically saying, they want a modification of the insurance agreement to treat as a specified third party as additionally insured. And so what they'll sometimes do, if you look at an A-Court agreement, and I'll have to see if I can find one and send it out. But typically, what they want, they'll say, add me to as on your certificate of insurance. So if anyone asks you for certificate of insurance, it does nothing. Okay. What you need to do is modify the actual insurance agreement to treat as a specified third party. A lot of times what they'll do is they'll say, I want to add me to your certificate, so they want a copy of it. But at the bottom of the A-Court agreement on the certificate of insurance, and it may list University of California, it'll also state somewhere that this does not modify the insurance agreement and performs no legal basis, something along those lines. But people always ask for it, but it does nothing. Okay. So you want to modify, and this is what this is really talking to, modify the insurance agreement. How do you do that? You want an additional insured endorsement. So what that does, an endorsement that adds coverage for one or more persons or organizations to the named insurance policy. It actually changed the coverage requirement of that policy. And so the insurance broker or someone will go, and if you look at the policy, it will name University of California as additionally insured. And that's really key. It's not just getting a certificate. Now, here's some of the advantages of that are listed. Rights under the policy that are independent of the enforceability of the general business contract between the transfer and transferee. Okay, plain language. Basically, if I'm additionally insured, I don't have to go through the company I'm doing business with. I can now put a request directly into the insurance company. So it has nothing to do with the contract that I have, that if something happens, I have a right under being additionally insured that I feel I have a claim that I can go directly to that company's insurance company to request, to be made whole. The waiver by the transferee's insurer of its right to subrogate against the transfer. So it includes, the advantage is in this case, the waiver by the transferee's insurer of its right to subrogate against the transfer. Okay, so we have that protection, that they can't subrogate. The additional source of funds to pay for the transferor's losses. In this case, so if we have a loss, that we now have a potential source of funds that will pay for this if it was caused by this other party. The right to demand that the transferee's insurer pay the cost to defend the transfer for a covered liability loss, again going directly to the insurance carrier. And free coverage because the transfer often does not contribute funds towards the payment of the transferee's insurance program. So in other words, by having an additional insured endorsement that they're doing work on our property, they're doing work for us, if something happens where normally we would get sued, we would have to handle it, we can basically say, well, no, this is the course and scope of the contract in which the contract was performing, and essentially say, you need to cover this. And at that point, again, we're not paying anything for that, we're paying the contract fee, and so we're not paying additional premium, but we have that additional protection by doing that. So that's some of the advantages. There are some disadvantages. Actually, I duplicated the slide here. Actually, make sure. Okay, did duplicate.
Additional insured is named insured.
Okay, that's right. Additionally insured, named insured. Okay, so the other part is named insured endorsement. So it's similar to insured endorsement, but elevates new insured to named insured with special rights and obligations. So typically, most organizations just want an additionally insured endorsement. A named insured endorsement is a little more specific in there, as it talks about, because there are special rights. And so there are some advantages, disadvantages to this. So under advantages, transfer's agents, employees, officers, directors are considered insureds and therefore included in the transferee's coverage. The transferor, as the named insured, is likely entitled to receive notice if the transfer's policy is canceled or endorsed. So, so if you're named, and that actually is a form of changing the policy by being a named insured, what that means is, and this is where the transferee policy is, that if something happens where the policy is canceled or has additional endorsements, because I'm named on the policy, I'm automatically going to be notified as if I was the insured, because I'm part of their policy now. So that's where the named insured comes from. The disadvantages by being named insured is the transferee's insurer may have a right to inspect transfer's business and financial records. So because they're included and we've been included on their policy, we have special rights. Well, that also gives the insurance company special rights to say, well, I want to take a look at what I'm going to have to pay for potentially. So they may want to inspect the facilities and things like that. The transfer may unknowingly be agreeing to provide periodic reports to the insurer, again, depending on what's in the contract, and the transfer may become involved in litigation unrelated to the relevant insurance coverages. So, meaning that because we're part of the policy, I'm not sure if this one probably happens that often, but if I'm part of the coverage policy, there's a potential that for whatever reason, that because I'm named insured, they see us as being maybe having a relationship or business relationship that we may be brought in. The last one I probably don't see. So you do want to know the difference between additionally insured and named insured and be able to describe those, and then finally know the advantages and disadvantages of basically each of those. So what are the types of transactions that you're going to find this type of language in? And really, I mean, it's really any contract, but we'll kind of go through a couple of these. Construction contracts are the most common. You're always going to have some type of indemnification insurance requirement language in those. Service and maintenance contracts. If people are performing, elevator service, they're going to be performing other types of things. There's going to be language in there that has things. Purchase order contracts. Within a purchase order contract, so a PO for as universities, POs are issued all the time as far as purchase orders. Usually there'll be some specification meeting the university's minimum insurance requirements as part of the contractual relationship. Lease of premises contracts, equipment lease contracts, bailment contracts, and then sale and supply contracts. So it's not important so much that you know these different types of contracts. I mean, you can think it's any type of contract for the most part is going to have some type of insurance transfer language nowadays. The last one on the sale and supply contracts is just, it's like shipping organizations, and there's usually a question that's going to talk about free on board or cost insurance freight. And the reason why is because it's somewhat unique, because the whole issue of free on board is when you, let's say you have a package from Amazon that gets delivered, at what point, and it gets damaged, whose responsibility for it if the damage occurs? And so there, within the different types of contract language, is it the carrier that's responsible? Is it the person that shipped that's responsible? Or am I just out of luck? Because of, and that also means inspecting it when it comes in, things like that. What are you signing for? And so, so a lot of times they'll be insured, they'll be part of insurance coverage. So that's the main thing you want to know for that portion of the, for this portion, though it talks about types of transactions, is really that last one of what does that really mean. So, getting to the, the contractual risk transfer common law liabilities, as we talk about these. So within without a contract, there's certain common law arrangements of who's responsible in the event of being negligent or a wrongful act, things like that. There's already common law agreements. But with risk transfer by contracts, you're actually altering some of these common law. And so there's different forms, and they kind of outline some of these in here, of what they call a limited form, intermediate form, and a broad form. And it talks about common law affecting transfers, potential or actual liability loss exposures can be altered by 3 forms of contract provisions. And for example, assume the contracting parties are a building owner and a general contractor. They may enter one of the 3 forms. And so here's the 3 forms. And essentially, the limited form, and there'll be a question about the different types. And so, not that it's going to go in detail, you just need to know which one's the one that really has the most which one's beneficial to which parties in which cases. So limited form, party C holds party O harmless for responsibility of losses that are exclusively party C's fault. Okay, so anything that party C does, party O, so the occupant, the building owner, we're going to be held harmless for all things exclusively. That's their fault. Intermediate form, or you might want to call it more fair use, I guess, is that party C holds party O harmless for those certain types of losses, and party C's sole fault on party C. Basically, it's joint fault. Basically, the idea under intermediate that it's a little fair. It's not as harsh. Typically, and just so also understand, under contracts, the goal of any risk manager is to make the contract more in favor to your organization. The goal of the other side is to make it more fair to their side. And so a lot of times what you see is more of that intermediate form. Is the idea of, okay, can the attorneys agree that things that we're responsible for that we did damage to, we're going to hold that. So party C in the last one, broad form, both parties talks about joint fault, and we'll go a little more, description of what those are. But basically, when we look at these, what are we trying to do? So the first one under limited form is transferring responsibility for joint fault. 2 is transferring responsibility except for transferor's fault. So transferring all responsibility except for the transferor's fault would be intermediate. And 3 is transferring all responsibility to one side or the other. So here's some language that for limited form that just kind of gives some context of what we're looking at, of what would a limited form contract look like. And if anything, you'll probably say they'll give you maybe some language like this and say what form, which of the forms is this, or something like that. Okay. So in limited form, the contractor agrees to indemnify and hold harmless the owner against claims, damages, bodily injury, arising out of the contractor's work and caused by any act of omission of the contractor's agents and his employees. So that's why I get protected. If you go to the last one on broad form, actually shorter language, it's probably the shortest amount of words. The contractor should indemnify and hold harmless the owner from against all claims, damages, bodily injury, whether or not caused in part by the owner's act or omission. So the broad form, basically, if I'm the university, this is the one I want to use, but most likely the other side would never accept it. Because it's even saying that if I do something because I didn't provide good information or did something, as a contractor, you're still on the hook for paying that claim. So that's where the broad form comes in. So in most cases, you're either going to see limited form or intermediate form, because most people, if they're reading the contracts, would never do a broad form if they have a risk manager on the other side. There are, it talks about in the book, limitations on these type of agreements. There looks like there's a question here. Let me see if that was going there. So the question is, in case of multi-contractors, whose insurance are responsible for damage? It really depends on, so if you're talking, let's say, on a work site, typically, as for a general contractor, and it depends on the scale of the type of size, and so this is kind of going a little bit beyond, but for a large contractor, they will have what's called a contractors construction, a CSIP, Contractors Construction Insurance Program. And what that is, what that means is that they're basically insuring the entire project. So if anything happens, even with subs, they're going to pay the cost of the claims. So all pretty much goes through them. And part of this is actually where attorneys get involved. So in the case of if it's ambiguous, if multiple parties were involved, what may happen is, and they're all different insurance companies. There'll be a discussion of, okay, how much liability is whose responsibility, and that's where it kind of gets litigated. It depends if there's a lawsuit. It depends on who's filing the claim, because typically part of who's going to be responsible is who the claim's being thrown against. So let's say we have several contractors on a work site. It's a UC property, and someone decides, something happens, someone's injured, one of the contract employees. So if it's contract employee, they're first going to go through their workers' comp because it's their thing. And if it was because of our negligence and the contract says it's our responsibility, then they're going to have to go after us for those dollars. If it was a visitor, let's say it's someone that was coming to the site to take a look, So it's a third party, and this is where it gets interesting. So you have a third party, they trip and fall because someone left, some piece of equipment out. At that point, the issue would probably become, well, whose piece of equipment is it? Now, the person, if they're injured because it's the university site, they would most likely cite the university, or they would go for a claim, file a claim against the university. At that point, the university would then have to decide, well, who was negligent, do an investigation, who was actually responsible. And we may take the original, say, okay, we'll handle this, or we say you need to actually go after this particular contractor. It really depends. But in most cases, there's usually one kind of contractor that would be most responsible, and they would handle it. But if it was multiple, then it's potentially that they would go after all three, and that's where an attorney would then basically sue all three organizations. And at some point, there'll be a settlement agreement which each one would pay a certain amount. And that's how those type of things would get settled. If it's a large claim, that's where it's going to probably happen, is that. So back on limitations of hold harmless agreements, there are statutory limitations, and it depends on the state. It's going to be a little different, but you have what's called all-inclusive statutes, and we'll describe some of these statutes prohibiting certain wording and statutes prescribing certain wording. So in the text, it talks about limitations that says what things can be covered. Well, and then when we talk about statutes prohibiting certain wording, they can say, for example, pretty much you cannot use gross negligence in any agreements in California anymore because of case law. But then they also might prescribe certain wording that says you must include certain types of provisions in there. And I think the textbook kind of talks about that. They're not going to ask what type of language, what would be a specific language. The main thing to know on this is that there are statutory limitations to understand that you may want to put a whole bunch of limitations on there, but it may not hold up in court. And so if you noticed on the agreements that I showed that it didn't say we have no liability. You can't really say we have no liability in the event of damage, but it needs to say something that we are going to accept this limited liability or something like that. And so that's kind of where those statutory limitations are. And most of these type of languages, it's because they've been tested in courts, and that's where they come from. So the main thing from a testing standpoint is just know that there may be requirements that allow you to put certain wording in or exclude certain wording, things like that, for the purposes of the exam. So when we talk about managing non-insurance risk and transfers and how does that work? So part of the first consideration we look at the contracts we have is enforceability. Is the language that we have, who's signing it? Is the language appropriate? Does it have language that's not allowed by law? So some of the considerations when you manage and you look at these contracts is to look at the enforceability. The other aspect is the ability to manage risk. Okay, so when it talks about this, when we talk about manage risk, it's who you're contracting with. Can they, one, do they have the proper insurance? Can they mitigate the risks that they're looking for? Are they a good partner to have if you're using a contractor? One of the things that most construction, if we look at as far as a bid process for contractors, we look at their experience modification. We want to see their insurance history. If they have lots of injuries, high insurance rates, things like that, they may not be the best in managing safety on their site. So managing risk might be part of that element. And then the other element is nature and extent of risk transfer. So the price or other legal considerations transfer explicitly or implicitly pays or gives the transferee. So actually it says extended, but that's nature and extent of risk transfer. So what are we getting for this? That they're getting a contract to do certain work, but in order to do that work, they have to maintain and have to indemnify and hold harmless. So part of the making sure that that is explicit of exactly what we're getting for that type of consideration. So in the administrative or strategic considerations it talks about is, it talks, in here it says the most important, first and foremost, and the reason I put that in here and did that is because, when they say the first and most important element is a consistent transfer strategy. And so most likely there's going to be a question dealing, if there is, it's going to be talking about what is the most important element that you want to have. And part of the reason why they say that is when you think about it is you want to make sure that you have, when we talk about transfer strategy, what are the contracts going to look like? What is the wording? What are the minimum insurance requirements that we're going to have as part of those transfer requirements? You know, as an organization, you should have standard language that you agree to. What typically happens with most small organizations is because they don't have a risk manager, they don't have it, they automatically accept whatever contract's put in front of them. Any contract with the University of California, for the most part, they have to use our contract language. We will not use their contract. They might, you know, there might be some negotiations with it, but we start with our contract language, so that is our transfer strategy. Is that we've reviewed it. It's been, you know, so we know where we want to go with it. And then some of the strategies that the organization does the following: becomes a transfer when this role serves both the organization and the general economy. Becomes a transferee when this role is similarly appropriate, and avoids assuming both roles simultaneously when appropriate. So what this is basically saying under this transfer policy is that sometimes we may become the transferee where we assume the risk of some of these things. So where would we assume a risk? Well, if we have our employees doing work and acting as consultants or doing you know, contracting work that because we're self-insured, we are now, you know, hopefully everyone recognizes that within an organization that we now become, we may be assuming new liability and entering into contracts in which we're now being the ones holding others harmless by performing that work. There are some cases which we've had some of our contractors are doing work for us that maybe they're ergonomists or they're part of a contract where we've essentially said we will waive the insurance requirements. By doing that, we've assumed their liability in the event that something does happen. So that's what it's talking about, is having, from a strategy, know when it's appropriate. These are the types of considerations that would be part of that. The other items would be general admin controls, records of contractual transfers, you know, thinking about specific control measures. How can risk be reduced and can provisions be deleted within a contract when you start looking at that? So when we talk about records of contractual transfers, I would also say with insurance agreements, part of the contracts will generally require that that they maintain insurance coverage, and so we actually have a company that helps, a software that helps us manage and monitoring the insurance requirements, and so that's part of, because as insurance goes away or a new company comes on, you want to make sure that you're protected during that time period. There's been many cases where the company all of a sudden doesn't have the insurance requirements, a claim does come up, and basically there is no transfer that's in existence because the policy was canceled and no notification was given. So these are the type of control measures when we talk about admin controls and records of contractual transfers. That's part of that. And then, again, some of the other measures you may want to include in there that they have to include. I would say for safety, for construction projects, we're focusing on that. That falling Cal OSHA requirements might be some of those things. Maybe they have to provide additional specific training that we require, and there may be, again, other provisions that might be deleted that are onerous for both parties. And the last slide I think we have here is the fundamental guidelines, and I think this is it's a good one-sheeter that they have in the book, and I would say best practices, and so one of the things that talks to the first one, ensure that the indemnitor can fulfill its commitment financially. Legal precedent mandates that the commitment be backed by insurance of at least $1 million per occurrence. I would say that's pretty much standard for any insurance requirement. Anyone you're doing business with should maintain at least $1 million per occurrence. It talks about require a certificate of insurance for contractual liability coverage before contract obligations begin. They put that in there, and this is actually one of that. It says require a certificate of insurance. It doesn't say additionally insured, it just says certificate. That does absolutely nothing other than to say they have insurance. But I would also say, and then the next one is be named as additionally insured. So on the transferee's policy, that's even more important. Is the most important aspect. And being added as additionally insured can pose problems such as increased possibility of policy cancellation. avoid being too severe, on there, avoid ambiguity, become more actively involved in legislation and those type of things. But I think this is a good, for this whole kind of chapter, it, I think, provides somewhat of a nice summary of kind of the whole issue of where contracts are and how we do move forward with some of those. So the question is, what is the difference between additional insured and additionally named insured? Okay, so the difference between the two, as an additional insured, I'm just listed as that in the event of a policy or something happening, I'm listed on the policy paperwork that I'm additionally insured. If I'm additionally named insured, that means my company name is actually in the policy language. So the certificates of insurance, the actual documents, will show me as a named insured, just as if the company was John Smith, HVAC service, I would also, you'd see my name within the policy documents that is being also additionally insured as UC University of California. Under just, and so it's probably tougher to be named, first of all. It's fine just probably being just additionally insured and not being additionally named insured, and I would say. So that's what you're typically going to find. But the main difference, and I think it talks about in the book a little bit more, is just the where you are in the policy, the actual policy itself. So if you think like a homeowner's policy or that coverage document that you get, it would actually name you as additionally insured versus just saying you're additionally insured for coverage purposes. Okay. So I was going to go back. At this point, is there any other questions? I was going to go back to the discussion on the Surety portion here. So we're waiting. Okay. All right. So I'm going to go back to the chart here. So kind of the question, because one thing I didn't cover specifically on here, it talks about the guarantee agreements. And the main difference I do want to point out on when we talk about a surety, but unlike a surety, a guarantee is obligated to perform only after the obligee has made every reasonable legal effort to compel the principal's performance. So when we talk about where the guarantor might sit, that's where that would be. But in this case, a guarantor would be a person or organization that has promised to perform a duty in the event that the party whose duty was initially the principal fails to perform it. So in this case, the guarantor, would be like the obligor or the principal. They need to make sure that the activity actually does occur in that case. And I think, let's make sure I go to the right area here. So, and actually, I'll kind of just read the language that's in the book just to help with this specifically. But the obligee is the party to a surety bond that received the surety's guarantee that the principal will fulfill the obligation performance promised. The principal is the party to a surety bond whose obligation of performance the surety guarantees, and the surety is the party, usually the insurer, to surety bond that guarantees the obligee to the principal will fulfill its obligation of performance required by the underlying contract, permit, or law. So the obligee is the party to the surety bond that receives the surety's guarantee of the principal. So the obligee, so again, it did have in there, is that this is the builder, the obligor would be the contractor, I'm the obligee if nothing happens. So the money paid to the principal, actually I think they do have this, the money would actually go to the obligee in here. So there actually is an error, it does look like in the book, based upon this. So I will, because I knew I had it right, I was talking about earlier. So the promise to perform, again, this is the principal has the promise to perform. If they don't, then the money would be paid, and so this is where would be paid to the obligee. The surety is really kind of the insurance company. So if something happens where they don't perform, I'm going to receive those dollars because they didn't perform. They're going to pay, the bond premium is going to be paid to the surety. So I'm going to pay, let's say for a $10,000 policy, I have to pay $1,000. I mean, it's 10%. I'm going to pay that. So in the effect that I do not perform, that $10,000 goes here. And then by doing that, I give a surety agreement that goes there. The principal promises to perform. But yeah, the money line I think is a little different there than what they're showing. So, but basically, that's kind of the idea behind this. So hopefully that answered the questions there. But Hans, good catch on that one. All righty. So if there's no other questions, we'll go ahead and conclude for tonight. I want to thanks again for everyone's participation. As a reminder, we will be going over chapters 9 and 10 on derivatives. It is more complicated section, so definitely take your time in reading it. But I'll also provide some other information on derivatives, and also to keep in context, I think now because of the mortgage and insurance-based derivatives, it kind of makes more sense for people because of that whole issue. So again, thanks everyone. We'll go ahead and we'll take a break, and we'll see everyone in a couple weeks.